This is Nayef Mubarak here. Just wanted to give you guys the latest update on immigration law. We just completed a seminar on the public charge rule, which went into effect on February 24th, this past Monday. And before we get started, I would like to introduce Attorney Joel Caminero. He joined our firm a month ago, and he's from DC. So I'll let him briefly introduce himself.
Yeah, so I just moved here recently from the DC area. I have lived and spent most of my life in Orlando, Florida, though, so I'm familiar with the area. I mainly practice removal defense, post-conviction relief, and appellate level matters. But yeah, I'm happy to be here working with Nayef.
And Joel actually served in the Navy, and I found out after he joined our firm, he went to the same high school as me. So it's a small world, and we are happy to work with our Orlando brethren and move forward. So what we're talking about today is this new form. This is a 944 form. It is now required for marriage cases or immigrant-based adjustment of status applications. A similar form is also required for immigrant visas that are coming from abroad through the U.S. embassies or consular process. This form is basically looking into the immigrant or the foreign national. What are their chances that they are going to rely on public benefits in the future? So they're going to look at age, education, job offers, financial ability, health insurance, and if you've received any public benefits from the government in the past. So some positive factors are as if you have private health insurance. A negative factor is if you're over 61. So for immigration practitioners like us, this is very worrisome for people who are applying for their parents. Just because they're elderly, immigration can view this as a negative factor. If you're under 18, this can also be viewed as a negative factor. So this is not affecting any application sent previously, but one of the biggest things you can do or mistakes you can make is obtain a public benefit that you're not entitled for, and that can be a negative factor in your future green card application. So if you have any public benefits, Joel, is there anything else you think that's important with the public benefits?
Yeah, there's just a little bit of a misconception. If you already have your green card, if you are already a lawful permanent resident, then this does not apply to you. So don't run out and try to relinquish all benefits out of fear. It's just be careful with that.
Yeah, so if you have an application that's pending already, and if you're a client of ours, please don't freak out. If we've already filed, you're okay. This is going to be a new form for the future. And if you are going to be a future client, it'll be okay. We just need to be prepared for it. The most important thing we need to do is stay up to date on the laws and changes which seem to be happening every week or day. There was even an update yesterday on citizenship applications, and we'll make a video on that very soon. So if you have any questions, feel free to contact us, message us below. Please share this information with your friends and family. So future applications for immigrants, even non-immigrants abroad, there's going to be a great scrutiny onto whether or not this person is going to be a liability of the U.S. government. So besides that, educate yourselves, have a great weekend, and we hope to see you around or speak to you soon.